Yes, we see.
My lords, at the time when we adjourned yesterday, I was showing the court the recent decision of the Supreme Court in the Tinkler case and the survey of previous important decisions on estoppel by convention. And I was just about to go to the discussion in that case of the bench-dollar decision. Before I do, however, please may I briefly address the answers to a few questions asked by members of the court yesterday.
By all means.
First of all, my Lord Master of the Rolls asked you two questions, which were at pages 150 to 151 of yesterday's.
Now, you've got a bit of competition outside today. Obviously, they're very interested in the case. And, but so you're going to have to speak up a bit.
I'll do my best.
I don't want to close the window. I think ventilation is desirable in the present climate.
I agree. Yesterday, at pages 150 to 151 of yesterday's transcript,
yes,
my Lord the Master of the Rolls asked me two questions. I started to answer the first question and gave an answer which appeared as though it was an answer to both of them. It wasn't a correct answer to both of them. The first question was, is there any insurance case where all these previous arguments have been rejected? That's to say, arguments about avoidance, common or unilateral mistake, affirmation. All of those arguments have been rejected, and yet estoppel by convention has been upheld. That was the first question. The second question was, is there any insurance case in which estoppel by convention has been upheld? I started to answer the first question and ended up answering them both as not so far as we are aware. Estoppel by convention is quite often run alongside a rectification case. And then my Lady Justice Andrews and I discussed cases of that nature. Now, it remains true, so far as we are aware, that there is no previous insurance case similar to this one, where an estoppel by convention has been upheld in circumstances where all of those previous types of arguments, such as avoidance, common or unilateral mistake, rectification, so forth, have been rejected and affirmation has been found. However, there are a number of cases in which estoppel by convention has been held to exist in an insurance context. Now, most commonly, that arises in relation to post-placement, indeed post-loss, communications. So, for example, we have in the bundle the Ted Baker decision, which was a case of a business interruption insurance in respect of theft by an employee. The insurance contained claims cooperation conditions, obliging the insured to provide quite a large amount of information in respect of a claim. There was correspondence between the insured and the insurers, in which the insured said, well, it's going to cost us a lot of money to provide this information. Would you please confirm coverage in principle? And there were meetings at which that was discussed. And the information was not provided. The insurers then rejected the claim on the basis that, one, it wasn't covered, and two, there had been a failure to comply with the claims cooperation conditions. And at first instance, it was held there was no estoppel by convention, but the claim wasn't covered. In the Court of Appeal, Sir Christopher Clark, giving the leading judgment, said that he would have held there was an estoppel by convention in relation to the correspondence about not needing to provide the audited reports, claims information, etc., but actually the claim wasn't covered anyway. So that's the most typical type of situation in which an estoppel arises in an insurance case. However, we are and were aware of one insurance case where an estoppel by convention was said to exist, albeit on an obiter basis, in relation to policy terms. And this was a case that was actually before the judge at first instance in this case on the topic of affirmation. And it's a case that's referred to in the judgment. It's the case of Moore Large, and we sent it through this morning.
Yes, got it.
And that was a case where there was an underlying dispute as to the maximum limit available under a credit insurance policy. The insurers argued for a lower historical limit that had been named in policy documents. The insured argued for a higher limit, saying it was the limit in place as at the date of the insolvency of the relevant company. And the insured relied, in support of its arguments, on policy construction. It said, well, the original policy, properly construed, says that it's this higher limit at the date of insolvency. Alternatively, if we're wrong, there was an endorsement 9, I think it was, to the policy, and under that endorsement, on its proper construction, including some surrounding correspondence, the higher limit applies. And they then said, but alternatively, as a fallback, if we're wrong on construction, the correspondence about this endorsement means that insurers effectively stated or represented that there was a higher limit, and therefore they are estopped by convention. And Mr. Justice Coleman decided the case on policy construction, and he in fact decided that even on its original unamended, unendorsed state policy provided for the higher limit, which the insured argued, and that the endorsement itself didn't change that, but in a brief obiter passage of paragraph 41 of the judgment, he said, for these reasons it is unnecessary to express any concluded view on the estoppel argument. However, had it been necessary to decide this point, I consider that Mr. Pugh's response to Mr. Humphrey's specifically expressed question represented that the insurers accepted that the only relevant date for application of the credit limit was the date of insolvency. Mr. Humphreys phrased his question by reference to two distinct and alternative dates. Mr. Pugh referred only to the date of insolvency and did not do so in such a way as to suggest that the date of the invoice also mattered. His response was sufficiently unequivocal to give rise to a representation sufficient to found an estoppel by convention, namely that so far as the insurers were concerned, the policy operated on the basis that the credit limit at the date of the insolvency alone controlled the right of indemnity. And he then explained what would have happened if they'd indicated that the date of the invoice or both dates were relevant. Now, we didn't focus on that passage at all at the trial because we were looking at this case as support for our arguments on affirmation. But looking back on it last night, it suddenly seemed to me that that was slightly redolent of the passages in the judgment where the judge did find estoppel by convention here based on a representation, and it may be that that was influential in the paragraph that he wrote. But I don't submit that more large, either other than being a case in which an estoppel by convention was held obiter potentially to exist in relation to policy terms, is either of assistance to me or my learned friend on the facts of this case. Perhaps if one were to say that one could never have an estoppel by convention in relation to policy terms, it's against such a submission. But my submission is not so extreme as to say one could never have an estoppel by convention, particularly if you have an insurer writing to an insured saying this policy is going to cover you on the basis of an invoice date at the date of insolvency. That one can easily understand why that would be taken to be an actionable representation. But I don't submit that there is anything particularly useful in the case for assisting this court to decide the issues on the case before us, but I thought it was appropriate to bring it to the court's attention, given one, the inaccurate answer that I gave yesterday, because I thought we were just talking about cases in which all of the previous arguments had been run and rejected, and two, because having looked back at it, as I say, it may well have been something that the judge in this case had in mind when he wrote what he did write.
Maybe.
Maybe it's speculation. The next point I wanted to touch on briefly was that my Lord the Master of the Rolls referred to the decision of Lord Justice Leggett, as he was, on rectification for unilateral or common mistake. That's the FSHC case. And I simply wanted to remind the members of the court that that case was before the judge in this case when he was dealing with the rectification claim, and is discussed by him at paragraphs 317 to 320 of the judgment. And perhaps if we could just briefly turn up those paragraphs of the judgment. They are page 103 to 104 of the hard copy bundle, which should be 105 to 106 PDF. And he there sets out at 317 the test for rectification in the FSHC case. It then refers to the judgment at 318. And then at paragraph 319, he refers to a passage in McGillivray on insurance, stating there is a presumption that a policy which is issued by the insurer and accepted by the insured contains the complete and final contract between the parties. Consequently, the court's equitable jurisdiction to rectify insurance policies is exercised with restraint inside certain well-established limitations, or else it would tend to destroy certainty in insurance business.
Yes, well, that was the passage I had in mind.
Well, I thought it might be, and I therefore thought it worthwhile to read the passage into the transcript so that we had a ready reference to it.
But it would be strange if we were destroying certainty in the insurance business by introducing estoppels by convention, but not by rectifying insurance contracts.
Well, that's our submission on this side of the court, my lord. And in the same context, my lord, you asked us to produce a list of paragraphs in the judge's earlier findings and holdings in the judgment.
Which you've done.
Which we've done, which we submit appear to have been lost sight of when the judge came to uphold the estoppel by convention. And we've compiled the list, we've sent it to my learned friend and the court.
It's quite striking, isn't it?
It is, and what's more striking is that it's been through several iterations because we kept finding more and more paragraphs. And we'd already pressed send, where we had at box 2 of the list in relation to the contrast between findings that Ark and Advent didn't read the policy and they weren't bound by the TPC through estoppel by convention, contrasting with earlier recognition that a party who signs a document knowing it is intended to have legal effect is generally bound, the Graucop principle. But we could have added there a reference to paragraph 638 of the judgment at pages 181 to 83, referring to what we discussed yesterday, the fact that insurers are presumed to know what's in the slip. And I haven't combed through all 1,025 paragraphs overnight, but it may be that we've missed another reference, but I hope our list is fairly comprehensive as to what we submit from the judge's earlier findings and holdings are irreconcilable with the eventual decision on estoppel by convention. Next, and this is by way of apology, when I was rereading the transcript last night, I was so excited that the court seemed to have some of my submissions in mind that I interrupted from time to time and didn't hear the end of a question properly. On one such occasion, my Lord the Master of the Rolls referred to the fact that many of the estoppel cases were not in a contractual context and said in the trio of cases there is one, in the contractual context isn't there. And I leapt in immediately to talk about the Sex Pistols and Jones and Liddon, whereas in fact if I'd listened properly I would have heard that my Lord the Master of the Rolls referred to Mr. Justice Hildyard, and therefore I think he had in mind the decision of the Court of Appeal, the earlier one in Blindley and Bass, concerning preemption rights in the shareholder agreement, which was of course a contractual case. Now Blindley was before the judge, and we also have it in the estoppel authorities for this court at tab 13, pages 474 and onwards, and I'll go to it briefly in the context of my references to Tinkler. So those were the preliminary matters I wanted to clear up, and now if it's convenient for the court, may I return to where I left off yesterday with Tinkler and the discussion of the bench dollar case, which I think I can take fairly briefly. We were in Tinkler, which is in the estoppel authorities at tab 15, page 523 onwards, and I have reached page 540, which refers at paragraph 8 to the exposition and application of estoppel by convention in the bench dollar case. Bench dollar was a decision of Mr. Justice Briggs, as he then was, and one can see that his exposition of the principles in estoppel by convention cases, if we turn over to 541, paragraph 45 of Lord Burroughs' speech in Tinkler, there's a citation from Mr. Justice Briggs' judgment at paragraph 52, in which Mr. Justice Briggs set out the 5 principles applicable to the assertion of an estoppel by convention. And that's at, as I say, paragraph 45b, at page 541. Those 5 principles are, number 1, the common assumption, which must be expressly shared. Number 2, the expression of the common assumption by the party estopped must be such that he may properly be said to have assumed some responsibility for it, such as conveying that he expected the other party to rely on it. Number 3, the person relying must in fact have relied on it, rather than on his independent view. Number 4, reliance must have occurred in connection with subsequent mutual dealings between the parties. And number 5, some detriment must have been suffered or other benefit conferred sufficient to make it unjust or unconscionable for the other party to assert the true position. And Lord Burrows then goes on to discuss another decision of Mr. Justice Briggs, and this is over the page at 542, with reference to the decision in Stenaline. And Lord Burrows said at paragraph 49 that it was unfortunate that Mr. Justice Briggs' first principle, which is to say that the common assumption must be expressly shared, made no reference to the need for the conduct to have crossed the line. And he explains that that was rectified, that omission, both in the Stenaline decision and then by the Court of Appeal in the Blindley Heath case. And this is referred to at paragraph 50 of Lord Burrows' speech in Tinkler. And Blindley is, I believe, the case that my Lord the Marshal of Rolls had in mind regarding the share preemption agreement. There was a share sale agreement in which shares were sold to outsiders. The previous shareholders had in fact entered into a preemption agreement requiring shares to be offered first to other existing shareholders, but both of them had forgotten about it. It was held by the judge at first instance that even though both of them had forgotten about the earlier agreement, an estoppel by convention applied because the parties had conducted themselves on a basis of a common assumption that there were no valid rights of preemption, and that it would therefore be unconscionable to allow the directors to go back on that. And Lord Burrows observes at the end of paragraph 50, while citing Mr. Justice Briggs' principles of apparent approval, Mr. Justice Hildyard, giving the judgment of the court, made clear in relation to the first principle that something must be shown to have crossed the line sufficient to manifest assent to the assumption. So, stepping back for a moment, Tinkler and Blindley were both cases of a common shared assumption. In that connection, paragraph 63 of Tinkler, which is over the several pages at paragraph 545 to 546, was an additional observation by Lord Burrows, in which he suggested that in most cases unconscionability will not add much to what is required for an estoppel when the other elements of an estoppel have been established, especially when detrimental reliance has been established. But he says there are exceptional cases where unconscionability could have a useful role to play. And we say this case, while it may not be completely exceptional, is a case in which, being a contractual case, unconscionability does have a useful role to play, in addition to a mere acting on the basis of an assumption or acting to detriment. And that, we say, is because of the fact it's a contractual case, because of all the other contractual principles requiring certainty where documents have been signed and agreed in the insurance market. That was all I was proposing to show the court in Tinkler. I was going to move on to a rather more relevant authority next, but I can do so briefly because I did unintentionally refer to it yesterday in answer to my Lord's question about a contractual case, and that's Jones and Liddon, the Sex Pistols band management contract case, the facts of which I referred to yesterday. We have it in the bundle of estoppel authorities at tab 16, pages 553 to 626. It's a jolly long case. I think it was something like 50 pages of single-spaced text, although having said that, that's probably not a sensible submission to make in the context of the judgment below in this case. But it's interesting because the reason it's long is because the judge regarded it as essential in considering whether there'd been acquiescence in Mr. Liddon's, Johnny Rotten's, assumption that he had a veto to establish whether or not the other band members had knowledge of that assumption on each of the 20 or more occasions relied on by Mr. Liddon.
I think he pronounces it Leiden.
I think you're probably right, my dear. Perhaps I shall stick with Johnny Rotten. The key passages on the need for knowledge, however, despite the length of judgment and the fact that there were 20 plus occasions relied on, are quite short. So looking at the judgment, first of all I wanted to go to paragraph 55 on page 570 of the bundle.
Sorry, para 55.
That's right, para 55, 570 of the electronic bundle. And this is where, having just cited Tinkler and the qualification to the principles for estoppel by convention in bench dollar, Sir Anthony Mann said, although that dictum refers to non-contractual dealings, the authorities make it plain that the same principles apply to contractual dealings, whence the doctrine originated. And he then refers to the gloss on the first principle that we referred to a moment about conduct needing to cross the line. Then at paragraph 56, he said it is necessary to clarify one additional matter in relation to the doctrine. The common assumption need not be a shared assumption if it is held by one party and the other party has acquiesced in the first assumption. This is apparent from the formulation in endurance, which he sets out. Paragraph 57, he said, this is significant in the present case because, as will become apparent, the individuals on the non-liable side of the matter never assumed that the BMA was not operative, nor had they forgotten about it. In his final submissions, Mr. Cunningham accepted that he could not rely on a common assumption about the existence or operability of the BMA, and that he had to rely on their having acquiesced in Mr. Leiden's alleged belief that there was no majority voting in place. And then there's a key passage that we rely on, paragraph 58. In the light of the fact that the acquiescence case has come to the fore, it is necessary to note that in order for there to be acquiescence in the assumption of another, it is necessary for the first person to know the assumption of the other. Mr. Cunningham accepted that proposition, so it's unnecessary for me to lengthen his judgment by including authorities about it. Then, moving on from there, at paragraph 62, on the following page, having referred to the attempt by Mr. Cunningham to refer to practically every form of estoppel known to lawyers, that's what's said at paragraph 61, and a reference to estoppel by representation. Paragraph 62, Sir Anthony said, these principles were not in dispute before me. Mr. Cullen drew particular attention to the need for the representation to be clear or unequivocal, or precise and unambiguous. In my view, there is no reason why that should not apply to all forms of estoppel involving a representation, even though that particular qualification does not appear in all of their formulations. There's no reason why a lower standard of clarity should be required for other forms of estoppel. And then he turns to the next paragraph, reliance on a proprietary estoppel, that's paragraph 63, then a reliance on a promissory estoppel, paragraph 64. Paragraph 65, Mr. Cullen pointed out that normally silence could not qualify as a clear and unequivocal promise or assurance, and refers to a citation from the Argo Systems case and says, I agree. At paragraph 66, Sir Anthony Mann said, there are some principles which can be extracted from the above authorities which are particularly significant in this litigation. The essence of an estoppel is that a party is forced to accept a legal factual position which is not necessarily the actual position. It gives effect to the erroneous belief of the person with the benefit of the estoppel because the other person has either given rise to it, usually by representation, or has shared it, estoppel by convention where there's a shared assumption, or has himself/herself gone along with that belief without actually sharing it. Bracket, estoppel by convention where one side acquiesces in the erroneous belief of the other. Close bracket. Estoppel by convention based on acquiescence fills a gap where a person is responsible for the belief of another without actually creating it in the first place by a representation. And he then referred to the speech of Lord Burroughs in Tinkler in that context, emphasising the last passage so that one can say D has assumed some element of responsibility to seize reliance on the common assumption. Sir Anthony Mann continues, the emphasis is mine, the acquiescence of the other party is what provides that element of responsibility. This is a point which is very important in the present case. And he then said, paragraph 67, so far as the representation versions of estoppel are concerned, it is true that representations can be by word or conduct, but if a representation is to be by conduct, then there must be facts which clearly demonstrate that the representation was being made. That will usually mean there is some context in which the subject matter of the representation is somehow clearly in the background to the conduct in question. It's not sufficient if the conduct would be consistent with the representation if it were made expressly. It must go further and actually contain the representation in an implied way. He says that's significant in the particular case before him.
So the analogy, really, that I drew yesterday between the two grounds for rectification of common mistake and unilateral mistake is really quite striking. I mean, obviously it's not identical, but there is a coherence.
Indeed, my lord. We would submit that that's so, and necessarily so. The law of contract is to maintain some internal coherence with all the principles that have been set out by the courts relating to it. But paragraph 67 paragraph 68, the judge makes clear that in final submissions, Mr. Cunningham, the first defendant's counsel, made clear at that point he was no longer relying on a shared or a common assumption. That he didn't challenge the claimant's evidence that they thought that the band management agreement was available to them. And then at 69, he said that so far as the claimant's side of the case is concerned, I am quite satisfied that none of the relevant individuals treated the BMA as becoming unenforceable, or that they considered that unanimity was always required in dealing with Sex Pistols' IP rights. And then he refers to the witness statement of Mr. Jones, that he'd already known about the agreement and the majority rules, and the fact that wasn't challenged in cross-examination, and that cross-examination went on to investigate the extent to which Mr. Jones was said to have been aware that, according to Mr. Leyden's counsel, Mr. Leyden thought it did not apply. And then the next passage that I wanted to refer to is at paragraph 81 on pages 576 to 577. And having considered the evidence as to what the parties themselves actually knew, and I pause there, the judge in this case thought it was relevant to consider the subjective knowledge and understanding of the parties. The judge went on to say, so far as the case is based on estoppel by convention by acquiescence is concerned, Mr. Leyden has to demonstrate not only that he believed brackets assumed the BMA to be of no effect and or that unanimity was required in rights decisions, also has to demonstrate acquiescence by the other band members in those beliefs, brackets, because a shared assumption is not relied on, close bracket. Mr. Cunningham accepted the proposition that acquiescence requires knowledge. One cannot acquiesce in something that one does not know about. So, in order to succeed, he would have to demonstrate that the other band members knew that he thought the BMA was of no effect, or that any member had a veto on rights exploitation. There is no evidence at all that they had such knowledge, other than such evidence as might emerge from the specific incidents referred to below. So these incidents will have to be scrutinised not only for evidence that Mr. Leyden had the belief he claims to have had, they will also have to be scrutinised for evidence that the other band members knew about that belief. I can at this stage summarise the effect of that evidence by saying that it in no way supports any allegation of knowledge until 2015. The judge then went on to consider umpteen incidents and encounters on that basis, and I'll just give you one reference by way of example. At paragraph 155 on page 594, the judge was considering a series of interactions regarding the London Olympics 2012, when there were discussions about the possible use of two Sex Pistols songs being played during the opening ceremony of the 2012 Olympic Games. And he goes on to find at paragraph 155 on page 594 that there was no common assumption. The evidence demonstrated the opposite, and there was no evidence demonstrating acquiescence in any belief by the first defendant that unanimity was required. The other band members had no cause to believe he had that assumption before or after this transaction. In the absence of such a piece of knowledge, there can have been no acquiescence. And there are other instances where he considers other possible uses of the IP rights and interactions between the parties, and in each case he reaches the same conclusion. So that was all that I was proposing to show the court in the Jones and Leyden case. The next case I wanted to refer to is the Starbev case. That's at tab 10, pages 342 to 406 of the authority bundle.
Jones and Leyden was not before the judge.
No, because the reason we had the supplementary skeletons is because they all came out after we'd filed our initial skeletons. So neither Tinkler nor Jones and Leyden was before the judge. They didn't come out until July this year.
Okay.
So Starbev is a decision of Mr. Justice Blair. It was a dispute about what payments were due under an agreement between a seller and a buyer for the sale of a beer business, pursuant to a typical venture capitalist sale and purchase agreement, where the purchaser was going to be aiming to develop the business and on-sell it, and the seller wanted to make sure that they would get the benefit of certain profits if they were made over and above a certain amount. The buyer, in the meantime, was going to have to invest money in the business and wanted to make sure that its investment wasn't taken into account in calculating that deferred compensation. And the claimant, Starbev, was the buyer. The respondent, Interbrew, was the seller. The issues that Mr. Justice Blair had to decide were summarised at paragraph 56 on page 352 to 353 of the judgment. The first issue is, what is the correct investment amount?
Why are we looking at this case?
We're looking at this case because it's relevant to the need for, it's relevant to the discussion of estoppel, which was obiter, because it was said, even if as a matter of construction, we're wrong about the investment amount, nevertheless, because we kept sending them notices saying, we think this is the investment amount, and they didn't say, no, that's wrong, we then went ahead and sold the business on that basis, and later they challenged it and said, no, we're entitled to it.
And did the judge say that was good enough?
No, and he said, one, it doesn't work on construction, and two, these were commercial parties, both of whom had advisors. Absolutely, they knew that there were going to be fights after the event about the investment amount.
Did the judge refer to the case? No.
He referred to the decision in Moorgate, Mercantile and Twitching, and the well-known obiter dicta as to the circumstances in which estoppel by acquiescence can arise. That's at page 368 in the extract from the judgment in the Indian Endurance at the bottom of paragraph 123, and he says that brings me to estoppel by acquiescence. The parties were agreed to protest for the existence of this kind of estoppel is to be found in the dissenting speech of Lord Wilberforce and Moorgate, Mercantile and Twitchings, and it's whether, having regard to the situation in the relevant in which the relevant transaction occurred as known to both parties.
What this case adds to the others, as I recollect, is that it talks about the state of mind of the acquiescing party when you come to the question of unconscionability.
Absolutely.
And that there is a parallel, as I recall it, drawn between unilateral mistake, although he doesn't draw that parallel, but he talks about the some conduct akin to dishonesty in taking advantage of the mistake made by the other party.
Indeed, and it was just those two paragraphs at 132 to 133 I was intending to refer to,
Yes.
where it was suggested that if you were an honest person, you couldn't resile from a convention that the other party had, and that was the standard. And halfway through paragraph 132, Mr. Justice Blair said he didn't agree with Starbeck that the phrase acting honestly and responsibly, which has been adopted in a number of cases, most notably Ros Rocker, can be read as meaning that irresponsible behaviour alone is sufficient. Plainly, the term acting honestly is intended to add something. In any case, it's not open to me to depart from the authority, even if I thought it was right to do so. The effect of the estoppel contended for is to prevent the other party to the contract from relying on its contractual right to audit and challenge the figures. These were both commercial parties, and there is no reason to apply a lower bar. And I do place some reliance on that observation, that in a contract between two commercial parties, the bar for an estoppel by convention is not a low one. And then just in the following paragraph, he says the question is what's meant by acting honestly for these purposes. It doesn't, in my view, necessarily imply that the party against whom the estoppel is raised must be guilty of actual dishonesty in the sense of acting fraudulently. It was submitted that a relationship of good faith or partnership or something akin to a joint enterprise, the courts impose a duty to speak in the absence of impropriety. He said, I would accept that way of putting it, subject to adding that the impropriety may come from staying silent itself, as where a reasonable person would expect the person who is alleged to be stopped. Acting honestly and responsibility would bring the true facts to the attention of the other party, known by him to be under a mistake as to their respective rights and obligations. See Mr. Justice Bingham and in Lutetia. So that was the only passage that I wanted to refer to. And
He was dealing with duty to speak situation, wasn't he? Because there is a line of authorities where if you know somebody to be labouring under a misapprehension, you have a duty to speak up. And he says, Mr. Justice Blair in this particular case, I think, said the fact that there's a state of uncertainty, or that you know that there may be some uncertainty as to what a particular term means, doesn't mean to say that one contracting party has to speak up and say, well, I actually think that it means this and you think it means that. It's very much on all fours, it seems to me, this analysis, with the common mistake authorities, where you only have a duty to speak if it would be sharp practice to keep silent.
Well, that's what we say, but then in order to try and be sort of objective and measured about it, we included a paragraph in our skeleton argument saying, well, of course, this is an insurance contract, and it's a contract of the utmost
good faith.
And in certain circumstances, that may be said to give rise to a duty to speak. We don't say that it does here, not least because we're talking about the placement of a policy where the duties of disclosure are plainly laid out in section 16 to 18 of the Marine Insurance Act.
But you don't even get there, surely, in the insurance context. You don't even get to that stage of the analysis unless it is known to the party who is said to have been fostering the assumption that the other party is labouring under a mistake.
Precisely, and that's why
That's
we went
the
to this
essential.
paragraph. But we weren't intending to raise a whole new argument about
No.
duties to speak. We were simply trying to address the point that was made in this paragraph. And that was it.
That's the only extra point, really, that one gets out of Starbev, and it doesn't seem to me to take this case much further, because you've actually got to get past first base in order to show that there's an estoppel, and there's no clear finding by the judge that the other party knew that there was a mistaken assumption as to what was meant by as expiring.
Indeed, my lady, that's what we submit.
Well, so far from no clear finding, there's no finding at all.
Right. I'll accept that correction from my lord.
I'll endorse it if I may. And those are the authorities that I was proposing to show your lady and your lords, my lords, my lady and my lords, in relation to ground one, knowledge and so forth. I wasn't really proposing to go to authorities in relation to the other grounds because they're very clearly set out in the judgment. There was just one other authority that I will mention in relation to our ground 3, and that's the case of National Westminster Bank and Soma, which is at tab 5.
Which was ground 3, remind me?
Didn't
Which was ground 3? Just
ground
remind me.
3 is is not unconscionable.
Unconscionable.
That hasn't been established, and that's a separate ground. And at pages 134 to 159 of the estoppel bundle, we have the case of National Westminster Bank and Soma, and it's more the facts of this case rather than particular dicta that I wanted to mention. This was a typical case of a case in which a bank mistakenly credits a customer's account with a payment that was in fact due to another customer. In this case, the customer had been looking out to see whether or not its particular sub-buyer was going to pay for some goods. And when it was credited with this sum and told this has been paid by your sub-buyer, it thought, well, obviously our sub-buyer is good for the money. We were expecting 70-something thousand. We've just been credited with 70-something thousand. We'll ship some more goods to them. And they shipped £13,000 worth of further goods before the bank discovered the mistake and said it's not your money. And in the meantime, the customer had gone under, and so they had shipped £13,000 of further goods that they weren't going to get paid for, and they were able to establish that there was an estoppel by representation from what the bank had said about this being the customer's payment. However, even though they had acted to their detriment in advancing further monies to the customer in reliance on that representation, the Court of Appeal held that the judge had correctly said reliance to your detriment in and of itself is not enough to satisfy the entire requirements of estoppel, and in particular, you only advanced 13,000, you didn't advance another 78,000. You can't therefore rely on the estoppel to the entire amount of the 78,000 about which the representation was made. And so if it's relevant at all, this case is just another example of an instance of the type that was referred to by Lord Burroughs in Tinkler, of an occasion on which unconscionability may add something additional to the normal requirements of estoppel. And the fact that even after you've established, and this is principally relevant to the respondent's notice saying that this court should uphold the judgment on the basis of an estoppel by representation, even if you found that there's a representation made and there's been detrimental reliance, it may still be right to consider the operation of equity, unfairness and unconscionability. So those were all the points that I was proposing to go to in the authorities. What I wanted to do now was simply to sum up and summarise our arguments in relation to each of the grounds of appeal and in response to the respondent's notice. Ground 1 was covered fairly thoroughly yesterday. In very short summary, in our submission, 1, there was no common assumption. 2, the parties were at cross purposes. 3, Edge did not know of Ark and Advent's assumption and therefore could not have acquiesced in it. 4, there is no finding of knowledge in the judgment, nor could there have been. 5, the necessary clarity as to what the assumption was is lacking. One can't...
Sorry, I'm sorry, just going a bit fast. Parties at cross purposes. 3,
Edge did not know of Ark and Advent's assumption,
yeah,
and therefore could not have acquiesced in it.
yeah.
4, there is no finding of such knowledge on the part of Edge in the judgment.
Yeah.
Nor could there be,
Yeah.
because Edge had an opposite assumption. 5, the necessary clarity as to what the assumption is lacking. One cannot get over that simply by referring to an assumption that everything was as expiry. First, because that meant different things to each of the parties. Secondly, as expiry was hedged about with exceptions such as save for matters discussed between us, save for immaterial changes. Who is to say what is a material or an immaterial change for the purpose of the assumption? And the court may remember that in one of the two submissions I made on the construction appeal yesterday, I took the court to an exchange at Ark about the effect of removing the sublimit on the fraudulent documents cover, giving rise to a potentially hairy situation of exposure. Well, that obviously must have been discussed with Ark, and presumably, therefore, there's no estoppel in relation to that aspect in relation to Ark. But Mr. Cook's notes don't make any mention of it whatsoever. He just says, as expiry, apart from an increase in the limit for oil and energy cargoes. So, for Mr. Cook, what is the assumption? Is he to have assumed that there was no change in the fraudulent documents cover and no removal of the limit, or not? It's just not clear. It's certainly not clear enough to found an estoppel by convention on the basis of a clear assumption. That was all rather a long argument in relation to my fifth ground. And my sixth reason why ground one must be right is that both Edge's subjective belief and objective conduct in handing over policy wordings containing the TPC are inconsistent with an acquiescence in an assumption by Ark and Advent that the policy did not contain TPC. And we have that from the findings in Judge's factual findings.
Inconsistent with... Sorry, say that again.
Those findings about what Edge subjectively thought and what Edge objectively did in handing over a policy,
Sorry, I've got that bit.
on both times are inconsistent with an acquiescence by Edge
Yes.
in an assumption by Ark and by Advent that the policy did not contain the transaction premium clause.
That the transaction what?
That the policy, an assumption that the policy did not contain the TPC.
Thank you.
That, in short summary, is why we say the appeal should be allowed on ground one.
Yep.
Ground two, I also covered to an extent yesterday in answer to questions from the court, so I can take it perhaps more quickly than I would have done if I were introducing it for the first time. This is that the policy contained clause 21, and that's called the non-avoidance clause. Could we briefly turn it up in the core bundle tab 10, policy, at page 379, which will be 384 in the PDF. It's easier, the same clause is actually set out in the judgment, the whole of it, at paragraph 464 on pages 137 to 140.
Yeah, well, we got it.
So we see that it is headed non-avoidance clause, but in fact that is only apt to cover what is stated in subclause A, and the express terms of the clause go much wider than that. It also curtails insurers' rights to rely upon any non-fraudulent misrepresentation or non-disclosure as grounds for a breach of warranty or as grounds for rejecting a claim. And we get that when we look at the policy provision. Underwriters will not, little c, seek damages for or seek to reject a claim for loss on the grounds of misrepresentation other than fraudulent misrepresentation, to highlight the words that are relevant for this appeal. And as I say, the whole clause was shown to the judge and is set out in the judgment in full, but the focus at trial was on little a in relation to insurers' attempt to avoid the policy.
But the distinction wasn't made at trial that it didn't apply.
No, but nobody talked about it because nobody talked about estoppel by convention in relation to the expiring.
No, exactly. But I accept that. But nobody, there wasn't an argument before the judge as to whether the NAC prevented the estoppel by convention at all.
Absolutely right, my lord, there wasn't. And we say if there had been, the answer would have been, well, obviously it does. The judge held correctly.
Well, it does, because the contract, including the NAC, has been affirmed.
Well, it does because in saying I wish to reject your claim because of a representation that the policy was as expiring, Ark and Advent are seeking to reject a claim on the grounds of a non-fraudulent representation.
No,
the reason why I'm holding back from affirmation, and I am going to address that now, is this.
Well, I mean, if there were no affirmation, it could be said, well, the NAC was not part of the policy we wrote.
Indeed.
Because it was new, and we didn't know about it, and that's what the argument is about. But affirmation puts the, if I put it this way, the kibosh on that suggestion, that it doesn't apply at all.
Well, affirmation does put the kibosh on that suggestion. It doesn't apply at all, for a reason I'll develop in a moment. But even if we hadn't had the affirmation arguments, the judge was right for the reasons that he held that the whole of the NAC was validly incorporated, and even in the absence of any affirmatory acts at all, would have provided a complete answer. Now, coming to affirmation, there was a great deal of debate and argument at the trial about affirmation when insurers sought to introduce a late amendment to plead avoidance. And we and the bank pointed to a very large number of what we said were affirmatory acts.
Yes.
Starting with the initial, oh, we've got a claim, it's a financial loss claim only, oh, well, this claim appears to be covered by the TPC, including a statement sent on behalf of the whole market to that effect, and going forwards. The judge analysed all of that, but because he was looking at the avoidance case and not the misrepresentation by reason of expiry, he focused on the fact that the defence, when served, did not contain a reservation of the right to avoid the policy. And he held that the defence, when served, was therefore an affirmation of the policy.
And that was because there was an argument that there had been such a reservation at an earlier stage of the litigation.
Indeed. We referred to a decision of the Court of Appeal in which it was said that all insurers and commercial parties know that you have to keep on reserving your rights. And they didn't reserve their rights when they served defence. The defence did, however, contain an argument that there had been an as-expiry representation, and that led to an estoppel. So the reason why I'm putting my arguments in the order that I am and saying, well, let's forget affirmation for a moment, the NAC is a complete answer, is because it might be said, well, the judge only found affirmation as at the moment of the defence, and the defence did leave open this argument. Now, in my submission, that would be a bad argument because one can't affirm parts of a contract.
Correct.
And if they've affirmed the contract in
affirmed
relation to the avoidance, they've affirmed the contract. But that's the reason why I didn't immediately jump on the affirmation bandwagon as my first limb to my bow. I've gone to the NAC itself because that doesn't even admit of the possibility of that argument. And in turning to the argument that I rely on primarily, which is the judge's findings as to the NAC, all of it being validly incorporated into the policy, being binding on all of them, he concluded at paragraphs 472 to 484 of the judgment that it was valid and operative on the facts of this case,
Sorry, which paragraph?
Paragraphs 472 to 484. And he said it therefore prevented all of the insurers, including Ark and Advent, from avoiding the policy on the basis of the as-expiry representation. Now, there's no appeal from that conclusion.
Sorry, 472
472 to 484.
Where did he say it therefore prevents?
He says at 484. I think
Oh, sorry, 484.
Yes. Oh, I'm so sorry. I
was
wasn't
looking at
speaking clearly.
474.
It's a section of the judgment that runs from 472 to 484, and it sets out the arguments and then rejects each of them seriatim. And then at 484, he says, there is no justification, therefore, for regarding the NAC in the present case as subject to a special regime, whereby, contrary to the ordinary reading of the clause, innocent non-disclosure or misrepresentation is sufficient. I conclude that the effect of the NAC is that any avoidance case must be based on fraudulent non-disclosure or misrepresentation. Given that no such case is advanced, the policy, including the NAC itself, survives, and the insurer's non-disclosure and misrepresentation cases fail.
That's including Ark and Advent.
Indeed. And that's including the as-expiry representation as a ground for avoiding the policy.
And it doesn't matter if you dress that up as one element of an estoppel by convention case.
Well, that's what we suggest. The judge should have concluded that the estoppel by convention case failed for exactly the same reason. Because by that case, Ark and Advent seek to reject the bank's claim for loss on the grounds of Edis' non-fraudulent as-expiry representation. Now,
so what I just find hard to understand is, having done all this at paragraph 482, whatever it is, he then comes back to the as-expiry representation and finds facts in relation to Ark and Advent. I mean, so this rejects the as-expiry case on the basis of the NAC.
Indeed.
As a representation giving the right to rescind or avoid. Right?
Yes.
But that's it, isn't it?
Indeed, and it's a little unusual that we then have, it's also a case that doesn't work because of affirmation, but it's very unusual.
Well, I mean,
we
affirmation.
then go on to say, but I'll state my conclusions as to whether there was inducement if I was wrong about both of the above.
Yeah. Well, I think it's what I said yesterday. It's that long judgments do have a habit of being written in sections.
And the occasional nodding of Homer.
Yes.
Well, it's almost as if the judge has forgotten what he was saying, because if you look at paragraph 694, where he is looking at the submissions made by Mr. Parsons, the submissions made by Mr. Parsons in connection with the estoppel argument is you can't rely on the NAC either.
That was the argument about it somehow being severable, or because...
When he rejected that, we've just seen that in the other passage. It's not severable.
It is, and can I just remind my lady that the majority of Mr. Parsons' submissions about the estoppel argument were not submissions about the as-expiry representation to Ark and Advent. They were submissions about the failed case, that there was an estoppel by convention because both Mr. Beattie and Mr. Mullen thought the TPC was a basis of valuation clause.
Yeah.
And the as-expiry was just a passing reference in an oral closing submission saying I rely on all the same matters in relation to Ark and Advent and the as-expiry.
Yeah.
So my learned friend valiantly, as he always would, attempts to get around this difficulty by saying, well, no, let's have a look at the NAC. It's a non-avoidance clause. that's what it says at the heading, and really clause C doesn't add anything to clause A. It means the same thing, or it's surplusage. We say, no, that's wrong. Subclause C is plainly different in meaning from subclause A. It's not mere repetition or surplusage. And although my learned friend says, well, estoppel is a rule of evidence, it's not a sword, it's a shield, and so forth. If one looks at paragraphs 29 and 57 of the defence, which are by way of estoppel, including estoppel by convention, the as expiry representation gave rise to an assumption. By reason of that, the bank is estopped from saying that it's covered for credit risk and financial defaults. Those two paragraphs are plainly an attempt to reject a claim for loss on the grounds of a representation, squarely within subclause C. So that's our ground two. And
just going back to the judgment again, it's the last sentence of paragraph 695.
Yeah, absolutely, my lady. Yeah.
Which is the one that has, when I first read it, I put a query by the margin because I just couldn't understand the rationale behind it. The potential argument of the advantage, the estoppel argument, is that it potentially circumvents the difficulties in their avoidance case, and in particular the effects of the NAC and affirmation. Well, it doesn't.
No, I mean, and we're speculating, the only way we think that could have been written is if the judge had subclause A and not subclause C in front of him, and had forgotten the subclause C was there as part of the non-avoidance clause. But it's a short clause, and he set out the whole thing in the judgment, so even that's difficult to understand.
Unless he somehow thought that the estoppel extended to the reliance on the NAC, in which case it would have extended to reliance on the NAC for all purposes, including the misrepresentation case.
Absolutely.
So it's totally inconsistent with what he's found earlier.
It is, yes. So we say, for that reason, our ground 2 should succeed quite independently of ground 1. And then ground 3 is saying an alternative ground, saying it's not unconscionable for the as expiry representation not to found an estoppel in this case. Now, the judge, when refusing permission to appeal, said in relation to this ground, well, unconscionability is a typical evaluative conclusion of the type that first instance judges are best placed to make. And that's absolutely something that we wouldn't challenge. But our ground 3 isn't a general and freestanding challenge to a factual or evaluative conclusion reached by the judge, but rather a specific legal submission on the NAC and the judge's findings and conclusions about it. And this actually overlaps considerably with what we've just been talking about in ground 2. The judge rightly held in rejecting underwriters' attempt to avoid the policy based on the as expiry representation that the NAC was a valid term of policy binding on all underwriters, including Ark and Advent. There's no appeal from that conclusion. Now, as discussed yesterday, one aspect of the judge's reasoning for that holding was the well-established principle of English law underpinning the whole of commercial life, that a person who signs a document knowing it is intended to have legal effect is generally bound by its terms, whether or not he's actually read them. Graucox, Brinwell, and so forth. We talked about that yesterday. Logically, the judge's conclusion and reasoning to this effect apply with equal force to the NAC in the context of Ark and Advent's attempt to reject the claim based on the as expiry misrepresentation. There's no sound juridical basis for saying that a different conclusion should be reached in relation to subclause C of the NAC from that which he reached in relation to subclause A. Now, given the very limited attention devoted to estoppel in the parties' written and oral submissions, particularly the as expiry estoppel alleged by Ark and Advent, that argument was largely lost from sight. There were no specific submissions on the NAC in the context of that. It's perhaps unsurprising that the judge's judgment on estoppel by convention doesn't specifically address it, given that the parties didn't. But the mere fact that Ark and Advent may have acted on an assumption that the policy did not contain the TPC, or a representation that it did not contain the TPC, that's if I'm wrong on my ground 1, That's not an end to the inquiry on unconscionability, as recognised by Lord Burroughs in the Tinkler case at paragraph 64. There are cases where there may need to be a separate inquiry, and we say that this is such a case because of the important commercial principles that apply when insurers scratch and stamp and sign a policy containing terms, and the need for commercial certainty. So those are my submissions on the grounds of appeal. My learned friend served a respondent's notice, and I just wanted to say something briefly about that.
Well, you can deal with it in reply mostly, but
I can. I think I can say something brief about it now.
if you
and
say something brief, if you want to poison our minds, we'll hear that, but we don't want a substantive reply to something that hasn't yet been opened.
It suggested that the judge should have found, and this is the reason I want to say something briefly about it now, is it's the point that was just raised by my lady, Lady Justice Andrews, as to whether it can be said that the estoppel by convention applies to the NAC, not the TPC. And my learned friend said, well, the judge should have found that. And we say, no, he shouldn't have done. His finding, to the extent he made it, was based on a finding about inducement in the context of the TPC, and there are no relevant factual findings that the underwriters were induced to write the policy because they didn't think it contained the NAC. My learned friend suggests that the Court of Appeal can make such findings. We say no, because all of the judge's findings point in the opposite direction. The NAC is not an unusual clause, it's not like the TPC, it's a clause that's been considered by the courts in many other cases. It even appears in marine cargo project policies sometimes. It's short, straightforward, not difficult to understand. And in a note email to the parties before we did our closing submissions, the judge specifically asked us to include in our closing submissions any factual findings that we wished him to make. And he was asked to make factual findings that underwriters were induced to write the policy because of the fact that the as expiring representation meant that it didn't contain the NAC, and he didn't make those findings. And then my learned friend has a respondent's notice saying that the judgment should be upheld on the alternative grounds of promissory estoppel. Well, we can see what he says about that, but we say promissory estoppel wasn't argued in closing, it's not in the judgment. That should be a reason in and of itself not to make an alternative finding upholding the judgment on those grounds. But even if I'm wrong about that, the promissory estoppel argument is bad in law for essentially the same reasons already developed in estoppel by convention. The NAC is just as good in relation to a promissory estoppel by representation as it is in relation to a estoppel by convention, estoppel by representation. The Graukow principle applies equally. The assumption wasn't clear. Well, if we're going to call it a representation, not an assumption, all of the same things are true. There plainly were some changes to last year's policy, that was made clear. They included the brokerage increase, changed the fraudulent documents cover to remove the sublimit, the inclusion of the expanded fraudulent documents cover. There was also a new missing goods clause, which was introduced for the first time in January 2016. My learned friend said in construction, and the reason I'm mentioning this now is so that he can respond. So on the construction appeal, he said the missing goods clause was effectively just the same as Section 58 of the Reinsurance Act, which deals with missing ships. We say no, it was part and parcel of what Northern Rose had come up with to try and give cover for goods that didn't exist. And that's not been the subject of any discussion or debate as to whether that was a material change, whether there's an estoppel from relying on that, whether the policy does or doesn't include it. There are not even any findings as to whether the NAC itself, as opposed to the TPC, is a material change. Because, of course, the judge said the representation was that there were no material changes to last year, other than X, Y, Z. For promissory estoppel, one needs detrimental reliance, and there's no evidence at trial and no finding in the judgment that they relied to their detriment upon a representation that the policy didn't contain the NAC, as opposed to the TPC. The judge didn't in fact consider detrimental reliance because he wasn't addressing promissory estoppel. He didn't find inducement, as I've said, on the basis of the NAC as opposed to the TPC. And in any event, why would it be unreasonable for them to rely why would it be reasonable, I apologise, for Ark and Advent to rely upon such unclear representations made on the very first occasion when they were approached with renewal risk by choosing not to read any policy terms. And then, as I mentioned yesterday, we also have a cross-appeal on the costs decision on the basis that if we were to win our appeal, we would ask the Court of Appeal to revisit the order that we don't receive any of our costs and we pay some of Ark and Advent's costs. But of course, any submissions on that can be made in writing, depending upon the outcome of the Court's decision on this appeal, if that's what the Court would prefer, as I understood the indication to be yesterday.
Indeed.
Unless I can help your Lordships and your Ladyship further, those are my submissions in support of the estoppel appeal.
Thank you very much, Miss Ely. Yes, Mr. Eggers.
One moment, my lord. My lord, I'm going to address the estoppel by convention appeal first, and of course then I'll deal my respondent's notice at the end of my submissions. But there is a degree of overlap between the two. My lord and my lady, as regards estoppel by convention, the judge's findings, we say, were entirely orthodox and in accordance with principle. The judge found, and it may well be worthwhile having paragraphs 672 onwards of the judgment available, which is at Core Bundles, tab 2, page 188. So what I may do is just take the court through the relevant parts of these passages, and the relevant parts are 672 to 682. Now, I'm sure that the court has read them already, but if you will indulge me, I'll just take you to a few passages. And then I want to make some general points based on those findings. The first concerns the representation made to Ark, where the underwriter was Mr. Blewett, and the judge expressed an assessment of his character as a witness. He notes in the second line of 672, I accept his evidence that his practice was to ask if there had been any changes to the policy wording, and that he would not note any material changes to the policy from the expiring year. Sorry, he would note any material changes to the policy from the expiring year. He described himself as an ardent note-taker, and he then refers to the contents of the note. And after that, he says, I'm satisfied that this was based on what he was told by Mr. Mullen or Mr. Lockyer, both of Edge. Whatever the precise words used, as to which there was some debate, I'm satisfied that their substance was that the only material changes to the prior year policy were those which had been specifically discussed. And this is what Mr. Blewett believed. So the representation there is essentially that the policy which Mr. Blewett was about to commit his, the insurer to was the same in terms as the expiring policy, save for those changes which have been discussed. And you can see that the judge equates the only material changes being those which have been discussed. And then at 673, the judge states that given that the Ark had not been told of, or given the July 2015 endorsement, this was a misrepresentation for reasons similar to those discussed in the context of navigators. So just to remind the court, the July endorsement had been presented to the leading underwriter alone, which included, amongst other things, the TPC. And it is found by the judge, at least in relation to Mr. Lockyer, Mr. Mullen, and possibly in relation to Mr. Lockyer, that they had thought that the following market was bound, but in fact the judge found that they were not, because there was no general underwriters agreement in the endorsement. But what's important, as the judge says at 673, is that neither Ark, and he makes it clear elsewhere in the judgment, Advent, nor any of the other following underwriters were given or informed of the endorsement, nor were the contents of the endorsement discussed with them. So that by reference to the endorsement, there was no means by which Ark or Advent were aware of the changes which were being brought about. And then the judge deals with inducement. And at 675, he says he's looked closely at Mr. Blewett's statement, reviewed the oral evidence, and he considers, and he said the key question of whether, if the representation had not been made, Ark would not have written the policy in the terms that they did. As to that, he says, I consider that there is. Mr. Blewett was concerned to note the changes to the policy. If he'd been told no more than was necessary to ensure that there was no misrepresentation, then he would have been informed that there had been a number of changes to the policy which had been agreed during the course of the previous year by the slip leader. This would have led to a discussion as to what those changes were, and the TPC would have been identified in the context of such a discussion. Mr. Blewett's evidence was he would have asked why the blank warranted that clause included, and he would not have agreed to the wording if he'd been shown the terms and reasons for their inclusion explained. I consider that Mr. Blewett's evidence is sufficient to establish inducement. And then he also refers to the peer review in order to support the case on endorsement of inducement. And similarly with Advent, the judge refers to Mr. Cook of Advent, and it refers to his assessment of Mr. Cook as a witness. And in paragraph 678, he states that Mr. Cook's notes record he was told about the increase in the oil limit, and also as expiry, but brokerage up from 22.5%. The evidence in his witness statement was that his standard practice for renewal step was to ask the broker about any changes to the policy and then to make a note of the changes. Where he notes as expiry, this means the renewal terms were brokered as being on the same terms as the expiring year. And again, he notes, I accept that evidence, which was not challenged in cross-examination. Somewhat belatedly, Mr. Lockyer said that his standard practice was to say that the slip incorporated endorsements during the expiring year. And then he refused to make that conclusion along those lines. And then he states in 680, there was again a misrepresentation when this as expiry representation is considered in its context. As far as inducement is concerned, Mr. Cook proceeded reasonably, in my view, on the basis of what he'd been told. As to the risk being expiry, his evidence was that he would always ask about any changes to the policy wording and make a note of the changes. Would therefore have noted the inclusion of the TPC had he been told that this was one of the changes. His evidence in his witness statement was that if the TPC had been shown to him and the reasons for exclusion explained, he would not have agreed it. And then in 681 and 682, he further discusses inducement. Although he notes, to be fair, at 682, that Mr. Cook's position on inducement was not as strong as Mr. Blewett's, but nonetheless he concludes that inducement existed. So, my lords and my lady, here we have a judge correctly and conscientiously assessing the evidence, identifying what was exchanged between the brokers and these two underwriters, and making findings accordingly. And the judge found, therefore, that there was a representation by Edge, via Mr. Mullen and Mr. Lockyer, that the policy contained the same terms as the expiring policy. The representation was made to Mr. Blewett and Mr. Cook of Ark and Advent, respectively. It was a representation made in response to questions asked by both underwriters. The representation was clear in that it was objectively understood to mean that the terms of the policy about to be placed were the same as the expiring policy. Indeed, with the exception of any material changes which had been discussed. And we saw, for example, with Mr. Cook, there were certain changes discussed, such as the brokerage and the limit. It's difficult to understand how else it could have been understood. The expiring policy did not contain the TPC or the NAC for that matter, but the policy as signed did. Therefore, Ark and Advent relied on the representation in two ways. One is by not reviewing the terms, and secondly, by committing themselves by signing the policy. And when they put their lines down, that is a contract as far as the insurance contract is concerned.
So where does he say that, the judge?
By my lord, which part? I'm sorry.
Where does he say that they relied on the representation by not reviewing the terms?
Well, I think
that was why they didn't read it.
Well, he says, just for example, in relation to So 681, I didn't take my lord to it, but so 680 I did take you to. So as far as, I'm looking at Mr. Cook, for example, as far as inducement is concerned, on the basis of what he'd been told as the risk being as expiry, his evidence was he would always ask about the changes, and he would make a note of the changes. And if he'd been told about the TPC, he would not have agreed it. In his oral evidence, Mr. Cook said that he had probably looked through the policy the year before, when he'd first written the risk, but if the broker says that it as expiry, you do not get any change, you do not expect any change. There's a lot of trust in our business. He said, and I accept, that there was no reason for him to carry out a review of the policy on renewal in the light of what had been told. He had been told. He said in evidence that in his experience there was a difference between the underwriting approach when the risk is first written, when an underwriter would go into some depth, and the position on renewal when he would not do so. And then he, as I say, he makes a comparison with Mr. Blewett's evidence and says that the case is not as strong, but still, nonetheless, it is there.
He doesn't say it expressly, does he, in either case?
Well,
Closest you get with Blewett is 674, Mr. Eggers.
I beg your pardon, my lady?
The closest you get with Mr. Blewett is paragraph 674.
Yes, but I think it's understood, though, throughout, also having regard to paragraph 680, that if he was told that the policy was the same as expiring, the natural thing, if he wasn't told that, the natural thing would be for him to review the policy. But if and for example, if the broker had said, yes, there are changes, but for example, the changes are too many for me to summarize, you should review it, he would have reviewed it. I think that's natural.
But he was told, at least one of them was told that there were changes and still didn't read the policy, even though he was told that there were some material changes.
No, my point, my lady, was if he was told there were a number of changes, but there were too many to describe. Here, of course, he was told that there were changes and they were described.
And still didn't read it.
He didn't, but because he was trusting the as expiry representation. And my lady, I would say this, the use of the phrase as expiry, both in terms of, as a policy term, but also as a statement made between brokers and underwriters, is usual. It's not unusual. And it has really only one meaning, that the policy about to be renewed is in the same terms as the policy which is expiring. It doesn't mean anything else. So as far as the underwriters are concerned, when they sign up to this policy, they believe, in reliance on what they're told, as the judge found, that it was in the same terms as the previous policy.
But anyway, the reviewers, as far as Ark is concerned, did review the policy.
The peer reviewers, my lord.
Yes.
But that's after they're bound. Once you're bound, you're stuck, and you are committed to a contract unless there is a reason you're not.
I know that, but
Yeah.
they reviewed it and didn't answer any questions about the TPC or the NAC.
But that doesn't.
676. No, I understand. But
Yeah, and it does. And of course, when we're looking at inducement, we're concerned with the inducement of these two individuals.
Of course.
No one else. So, my lord, if I may proceed, it is important to understand that when one is considering inducement, which the judge found to exist, there is a general principle, not just in relation to estoppel, but also in relation to misrepresentation at large, in terms of a breach of the duty at tort or breach of the duty of the utmost good faith, that it doesn't lie well in the mouth of the person who's made the misrepresentation to say that the misrepresentee should not have relied upon the representation. So if I can make that point good, if I could ask your, my lords and my lady, to take up the authorities bundle. This is the.
So what's the proposition again?
So very simply, if the representation is made by a representor to a representee, and the representee relies on it, the representor cannot argue, in general terms, for example, that the representee was at fault or negligent or careless in relying on it.
I don't think anybody's suggesting that.
No, but I'm just making the point.
What's the authority?
Well, I can take you to, it's well established.
What is it?
It is, my lord. But can I take you to the authorities bundle? And it's tab 21. This is a commentary by Cartwright, having looked at the authorities. And it's tab 21, page 652. So you can see the heading, my lords and my lady, the representee's own fault. In claims of misrepresentation, the relevance of the claimant's fault varies from one remedy to another, but in general, the representor who intended the representee to act on the representation cannot be heard to say that the representee should not have relied on representation, but should have checked its accuracy. Similarly, where a defendant raises an estoppel by representation on the basis that the claimant intended him to rely on the representation, the claimant cannot say that the defendant should not have so relied, if in fact he did. Now, there's only a paucity of authority referred to in footnote 98, but I can assure my lords and my lady, and I can provide the authorities if necessary. This is a well-established policy. My Lord Musgrells, I haven't read too much into your...
Sorry?
I saw my lord raise his eyebrows. I didn't know if you would...
Well, I'm not sure it's the point, is it?
No, it may not be.
I didn't hear Miss Healy say that they were negligent in relying on the representation.
No, I saw that. I appreciate that. I just wanted to make the point. That's all. We say it doesn't matter why they relied upon it. There was a finding of inducement, which the judge found, after a careful consideration of the evidence. The assumption as to the contents of the policy, in particular its inclusion of the TPC, was itself created by that representation. And that's what the judge found. It's paragraph 697 of his judgment. Now, if there is no estoppel, and I can take, sorry, my lord, it's just a reference, but I can take you there if you wish. So there's the last sentence of 697 is a finding that the assumption made was itself the product of the representation made by the brokers.
So you accept that it's an essential part of the estoppel case that there was a misrepresentation, albeit an innocent one?
Yes, there was no allegation of fraud, my lord. My lady. No allegation of fraud at all. But there was certainly a misrepresentation, and it was an innocent one.
Yes. Well, that wasn't quite the question I put to you. Do you accept that it was an essential ingredient of your estoppel argument that there was a representation?
Yes, I do.
Yeah.
I don't think I've put it in any other way. I'm sorry if I misunderstood your question. If there is no estoppel, then Ark and Advent would be prejudiced by their reliance on this representation.
And do you accept that acquiescence requires knowledge?
I do not.
You do not?
At least in the case of acquiescence, which is manifested by a representation.
That was what Mr. Justice Mann was talking about. You say he's wrong.
I would say, I'll go this far. I think there are only, and I will come back to this, so forgive me, but Ms. Healy referred to two authorities, I think, which make, according to her submissions, make good the point that knowledge is a requirement of acquiescence in this respect. Starbev and Jones and Leiden. And I want to explain those cases in a little bit more depth, so rather, but what I will say is this. The bedrock of my submission to this court is where there's an estoppel by convention based on acquiescence, knowledge does not have to be established in the case of where the assumption is created by a representation. The representation itself represents the acquiescence.
Is there an authority that you rely on for that proposition?
Well, I think this may be, as far as I'm aware, this may be the first case where the issue will be considered. Because the two cases, which Starbev and Jones and Lydon. Jones and Lydon, there was a separate allegation of estoppel by representation. But as when I take the court to the judgment, you'll see that the judge, Mr. Sir Anthony Mann, was distinguishing estoppel by convention based on acquiescence on the one hand from any estoppel which is based on a representation. And similarly, in Starbev, there was no allegation in that case of a representation giving rise to the estoppel by acquiescence, or estoppel by convention.
Isn't that knowledge, forgive me if I'm wrong, I may be wrong, isn't that knowledge suggested also by Lord Burroughs? Don't you have more difficulty overruling him?
Well, I think there, of course, Lord Burroughs was really considering a commonly shared assumption, not an estoppel by convention based on acquiescence. He's not considering it.
So it may not be ratio.
I don't think he was considering it at all.
But he does mention that you need knowledge.
I
mean, or am I wrong?
I think you're wrong about, in this context, he's not discussing acquiescence in this context.
Well, I look forward to the way in which you put the argument that you can have a concept of acquiescing in something of which you do not know.
Well, my lady, this prefigures my submissions which are to come. So,
Yeah.
but, and there's no criticism of my learned friends, but when in their supplementary skeleton argument, when they deal with acquiescence, they identify a large number of cases which are actually concerned with a separate species of estoppel, which is estoppel by acquiescence, which is a topic which belongs to proprietary estoppel, promissory estoppel. It's separate from estoppel by convention. And there's a subspecies of estoppel by convention, which is shared assumption or acquiescence. Now, in the estoppel by acquiescence cases, what it normally refers to is a scenario where one party is aware of another party's mistaken assumption or mistaken belief, the way it's put. And secondly, there's a duty to speak. And therefore, if for example, you're aware of a mistaken belief, there is no duty to speak, no acquiescence arises. But there are different types of case. In our case, what we're really concerned with is the making of a representation, which is understood objectively in a particular way. And it's not only understood in a particular way, it's also to be assumed, it's intended to be understood in objectively.
Well, that might give rise to a misrepresentation case.
And estoppel by representation as well. But as far, I'm sorry, I interrupted my lady.
Well, all I'm putting to you for consideration is that to acquiesce in something, actual concept of acquiescing in something, means that you must know that to which you are assenting. You can't assent to something that you are ignorant of, as a matter of plain English.
Well, my lady, that's right where you have silence and a duty to speak.
No, it's right as a matter of English, Mr. Eggers. You can't assent to something as a concept unless you know that to which you are assenting. You are saying yes to something of which you're completely ignorant. That makes no sense.
I'm sorry, I don't agree with that. I'm sorry, my lady. And you may say, my understanding of the English language is imperfect as a result. But the truth is, for example, when one speaks of assenting or consenting to a contract terms, you sign it, you consent to it. You may not fully understand what you're consenting to. What the court is concerned with is the objective understanding represented by the terms of the contract.
No, but acquiescence is an equitable concept.
But similarly, my lord, I'm sorry, I don't mean to interrupt. Well, I do.
But the point is you're comparing apples with pears.
Well,
you're talking about the legal concept of whether you're bound by something you sign, whether you know about it or not. My lady's talking about whether acquiescence, which is an equitable doctrine, or part of an equitable doctrine in this case, requires actual knowledge, or whether it's a very unusual use of language to say you can acquiesce without knowing, because the whole concept of acquiescence is that you know that something's going on. It's because it's about equity, which is about subjective concept.
all the acquiescence cases which you'll have been considering in this context are not based on representation. They're based on silence. And here, the difference is that one party,
You just hang on a second. I mean, you can't quite say that because Lord Burrows makes it perfectly clear that you have to qualify bench dollar, and so does Lord Briggs, because there must be a crossing of the line of something being said.
correct. And here there is,
Yes.
which is the representation.
Here there is. Yes, and there's not a crossing of the line about the understanding.
No, but, well, it is, my lord, for this reason.
Yeah, because they're at cross purposes.
No, my lord, it is for this reason.
Well, you accept they're at cross purposes.
I accept that on the evidence, and in accordance with the findings of the judge, that Mr. Mullen and Mr. Lockyer were taken to believe that when they made the representation, they believed it was as amended in accordance with the endorsement. And when the underwriters at Ark and Advent received the representation, it was on the basis that it didn't contain the TPC and the NEC, which was not.
I think shorthand for that is they were at cross purposes.
Yeah, yes, I'm sorry. I was trying to explain why I was.
No, I understand why you say. Yeah, okay. So
Yeah.
keep going. I'm sorry,
Okay.
I interrupted you.
No, and I'm sure I interrupted you, and I didn't mean to, although I probably did. But the important thing, I want to come back to this, but as far as acquiescence is concerned, what I would say is this. Given that estoppel, by convention, is very much concerned with the manifestation of conduct and the crossing of the line, in circumstances where we're speaking in terms of an assumption being created by the making of a representation which was intended to be relied upon, and that representation objectively had a particular meaning which the judge found to exist, anyone making that representation should be taken to have acquiesced in any assumption created by it. So, in other words,
Even if they've got no reason to believe that the other person has made that assumption, because they're expecting that other person to believe as they do that the lead underwriter binds all the following market.
well, my lady, there was, they may have believed that, but the fact is that the judge
Sorry,
also.
I am interrupting you now
Yeah.
because it seems to me that submission is very important, and I want to make sure that
My submission.
Your submission. I want to get it down. An estoppel by convention is concerned, you said, with a manifestation of intention.
Well, manifestation of the assumption.
A manifestation of the assumption.
Yeah.
That's what I've written.
A crossing
I
of
just
the line.
changed it. Right. Manifestation of the assumption. If a representation has a particular meaning, or had a particular meaning, objectively, anyone making that representation must be taken to have acquiesced in that meaning.
Firstly, must have been taken to it and intended it to be relied upon,
So it must be taken to have intended it to be relied upon.
and therefore acquiescing in its meaning when, if accepted, relied upon by the representee.
And therefore acquiesced in that meaning.
Yes.
Okay.
And that's what this case, why this case is at odds, my lord, with the other acquiescence cases, because it's based on representation, not anything else. In the ordinary case, it's a duty to speak where there's silence. So no one said anything, even though they ought to have said something. Here, something was actually said. And you can see, I mean, my lord and my lady, you can see it when it comes to the general law of the utmost good faith. You have a particular approach to the obligation to disclose material information. And then you have a separate branch of the duty not to make a misrepresentation. Now, the courts traditionally view, they may have come to the view a particular circumstance should not be disclosed because it's not material. But once someone has said something, it acquires, not always, but often the utterance actually acquires materiality. So if it's untrue, it will be treated as a breach of the duty of utmost good faith.
Can I just ask you this,
Yes.
because it sort of underlines my thinking, and it's
Yes.
helpful to have your answer quickly, because I keep on thinking about it.
Of course.
He dealt with representation, this representation.
This judge, yes.
Yeah, this judge, and he said it was bounced out and not it couldn't have avoidance
Yes.
or rescission
Yes.
or misrepresentation because of the NAC.
Correct.
Right. How does that square with your case being based upon that representation in order to found the estoppel?
Well, I've got two answers to that, if I may.
Okay, well, that's what I want.
Well, and I hope to.
Right, one would be good enough, but if you want to give me two, Mr. Eggers.
Well, if I can do three, I'll stretch it. But the first is this: the judge dealt with a number of allegations. I'll give you the two answers in a moment. If I could just lead up to it.
Yeah.
The judge made a number of allegations as to non-disclosure or misrepresentation in the context of the duty of the utmost good faith. That's an allegation by the underwriter.
In the context of
the duty of the utmost good faith.
Yes, yes.
Sections 18 and Section 20 of the Reinsurance Act. The judge dispatched them first, and including the as expiry representations we're considering now. There were one of, I think, 5 classes of
Yes.
breach. And I can give you the references if you need a bit.
We're unfortunately quite familiar with this rather lengthy judgment. Yes.
Well, but just for you, the table of contents is a very useful summary of what the issues are. And the first thing the judge did was to determine 2 issues. One was, and I'll probably get the order wrong, but the first one is the application of the NAC, which excludes the right of avoidance, amongst other things. I'm not saying it's only limited to right of avoidance. And secondly, to deal with the question of affirmation. So, and this is affirmation is important because the remedy which was being sought to be exercised was the right to avoid the policy. And the judge held, by virtue of the affirmation, that the right to avoid was lost. So the contract still existed as a contract. It couldn't be set aside as if it never existed. So in answer to your question, my lord, the first thing is this, that none of the other allegations of non-disclosure or misrepresentation which the judge rejected, were inconsistent, or he didn't always reject them, but were inconsistent with the findings in relation to the as expiry misrepresentations.
Sorry, you've got to say that more slowly.
I'm
None
so
of
sorry.
the other...
Findings which the judge made in relation to the other allegations of non-disclosure or misrepresentation were inconsistent with his findings that there was a misrepresentation, that the policy was as expiry, which was made to Ark and Advent.
So, okay.
That's the first point I was...
Okay, I just want to get
Yes.
it down correctly. None of the other findings about other allegations of non-disclosure or misrepresentation were inconsistent with his finding that
there was a misrepresentation to Ark and Advent that the policy was as expiry.
Yeah.
I use that as a shorthand.
Yeah, no, that's fine.
The second point is the fact that the judge dismissed the case based on a breach of the duty of the utmost good faith by reference to the as expiry misrepresentations was based on his findings as to the application of the NAC and the policy affirmation.
Okay, you've gone too fast again.
I'm so
afraid.
sorry.
The fact that the judge dismissed the case based on a duty of utmost good faith
Yes,
by
by reference to the as expiry misrepresentations. This is to Ark and Advent.
Yeah.
Was based on the application of the NAC and policy affirmation.
Yeah.
Nothing else. As regards the misrepresentations himself, he made findings which were in favour of Ark and Advent.
Otherwise, he made findings in favour of Ark and Advent.
Yeah. And so now, as far as we say, in response to that neither the NAC on its construction or the policy affirmation detract from the establishment of an estoppel. I'm going to come back to the NAC because it's the second ground of appeal. It also arises separately in relation to estoppel by representation. But I just deal with policy affirmation now. Although if you wish, I can deal with NAC now. But as far as policy affirmation is concerned, we say that is irrelevant to the reliance on an estoppel or the finding of an estoppel, whether by convention or representation, for this reason. Policy affirmation is essentially a waiver of a right to avoid. It's the loss of the right to void. It's not the loss of any other rights which the misrepresentation or the non-disclosure may give rise to. And the reason for that is an affirmation is a waiver based on an election. And it's well established that when one is faced with a breach of duty of the utmost good faith, the insurers have a right to avoid, but it's not automatic. They have to make a choice. Do they want to set aside the contract, or do they want to keep it in place? But if any statements or conduct by them is inconsistent with the avoidance, then it will be treated as, the policy will be treated as having been affirmed.
Can I ask you a question?
Yes.
Maybe a very stupid one. What is it that they are electing to keep in place if they make such an election?
If they affirm, my lady.
What is it that they are electing to keep?
They're
in
electing to
place?
keep the policy which was voidable.
The whole of the policy, or bits of it?
No. I accept avoidance is concerned with the entirety of the contract, not.
So they have done something which amounts to a positive adoption of a binding contract, including all of its terms, instead of exercising a right to set that policy aside.
Well, no. I don't mean to quibble, but forgive me. But what they're doing is saying we are not avoiding the contract. So the contract remains in force until it's avoided.
Yes, but
once
what remains in force is the contract as signed, as a whole.
Yes.
Not something different.
No.
That contract.
Correct.
Well, if you elect in those circumstances to adopt that contract as a whole,
Yes.
which must include the TPC,
Yes.
how can you then say you are stopped from relying on the TPC?
Well, just the answer to that is twofold. The first is this: that the operation of estoppel by convention gives you the right, if the estoppel exists, to treat the contract as exists, as if it did or did not contain certain terms, amongst other things. Or it may give you the right to treat the contract as if certain terms should be interpreted in one way rather than another. That's what an estoppel by. Now, in many cases, you're not really concerned with avoidance or affirmation because the contract is always there. And so if my lady's point was correct, anyone who's raising an argument about estoppel by convention in relation to either what terms were contained in the contract or not, or as to what meaning should be given to the terms in the contract or not, would always be faced with the argument, well, you signed up to the contract.
No, because it's not the signature of the contract, it's the positive step to affirm that contract in the knowledge that you might have the right to set it aside for the very conduct that you complain of as founding your estoppel.
No, I disagree with that, because my lady, for example, if I've got I don't mean to be combative, I'm sorry.
No,
Yeah.
it's important.
So if that were correct also, another consequence of that reasoning would be that if a representation was made, misrepresentation was made, and I had a choice, I could well, not even a choice, I have cumulative remedies. I could avoid or rescind the contract, or I could sue for damages. And it doesn't have to be fraud, because damages are available under the Misrepresentation Act of 1967. And in those circumstances, just because I affirm the contract, my other remedies are in place. And it's the same with an estoppel.
When you look at the law of rescission,
Yes.
law of rescission, one of the bars to rescission is delay.
Yes. Avoidance is. I don't mean to squibble, my lord. I'm sorry, forgive.
And
rescission
the
is-
point, just to make the point I'm making is if you don't rescind,
Yeah.
and that means actually rescinding, saying I'm not bound by the contract because of the representation you made, you are bound by it. So what I don't understand, I mean, I suppose your point is the one that Miss Healy was so keen to make sure she didn't ride roughshod over, which is that you, when you affirmed, you had already pleaded estoppel. So any affirmation that the judge found succeeded the plea of estoppel, and we have 200 paragraphs or something of all that stuff, and therefore it left the resolution of that estoppel in place. Is that what you said?
Yes, although I
Is
don't.
that a stronger argument?
It is
than the one
stronger
you're-
because
you're-
it's
if I may
stronger.
say so?
It is stronger because of that. Although I wouldn't want it to be thought to be said that even if the events were reversed in time, that somehow my position changes. I'm not saying that, but I accept that it makes my position stronger.
Doesn't matter for this purpose.
Yeah.
But so you say, well, I reserve my position as to rescission. Rescission had to be tried, and when it came to be tried, on this point, I can succeed. But that then leaves you in the position of having a finding that you could not rescind because of the NAC.
Yes, well, if I may, my lord, this is the second point. Affirmation actually becomes irrelevant because there was no right to avoid in the first place because of the terms of the NAC.
Right.
So nothing was affirmed because there was no right to avoid, and therefore no right to avoid was lost.
Right.
So the affirmation, it was an alternative finding by the judge on the assumption that the NAC did not apply. And when I said second point, I meant second point to my ladies.
So that's fine for affirmation.
Yes.
How does it deal with the finding that you had no right to rescind?
Because I don't think the existence or non-existence of the right to rescind or avoid the contract is relevant to the establishment of an estoppel.
Well, that's what I didn't understand. If it's an estoppel representation, and the right to rescind is based on the same representation.
But it's the same. But I still have a claim for damages, which is unaffected by the NAC. Well, it's affected by the NAC here because it refers to damages. But if it didn't, it was just limited to avoidance, for example, and it didn't apply to damages, the right to damages would still be maintained. So just because
There's no right to damages for innocent misrepresentation.
there is
Only
under Misrepresentation Act,
only under the Misrepresentation Act.
which is
And it was
includes
not
non-fraudulent.
claimed, and not claimed.
Not in this case. No, I'm just debating the.
Yeah, but I mean the point I'm making to you is, and I still don't think I have a satisfactory answer.
Yes.
You read out your two answers to me.
Yes.
I still don't think I have a satisfactory answer to the fact that the judge decided that you could not avoid the policy on the grounds of the representation
Correct.
as a matter of law
And contract.
and contract fact and contract because of the NAC.
Primarily because of contract.
Sorry?
Primarily because of contract. Because the affirmation arises only of the contract.
So I just don't see how in the face of that decision he can then say that the representation amounts to an estoppel by acquiescence that has the same outcome.
Because the estoppel, well, first it's a question of construction of the NAC, which I haven't come to yet. But
Well, it doesn't prevent you relying on an estoppel.
yes, we say the NAC doesn't prevent one relying on the estoppel, and there's nothing inconsistent.
It prevents you rejecting the claim,
It does. That's what the clause says.
and that's what you're doing.
No, I want to address that's indirectly what we're doing. That's not what the estoppel does. The estoppel does something slightly different. What the estoppel does is to treat the contract as if it did not contain certain terms. So, for example, if the relevant claim was not dependent on the TPC, the estoppel would still operate. So now, I'm really, I'm
So
not
you're saying
developing
because
submissions.
it's a doctrine, an equitable doctrine of evidence.
And justice, it's a principle of justice. We use the court's phrase on a number of occasions.
We in the Chancery Division always thought that equity had something to do with justice, but I entirely understand that that's not shared in the commercial court. But
I didn't mean to display my prejudice, man.
I think you were. Okay, well, I mean, I see roughly where you're going.
But I haven't developed the construction argument yet, and I will, I promise.
No, okay, well, well, I think even you would accept it's convoluted.
No, my lord.
I think you would. I'm not requiring you to do so.
The effect, I think, of what you're saying
Yes.
is that what ends up being affirmed is a different contract from the contract that everybody else has signed up to.
No. Well, I think in one sense, in effect, but not technically. Technically, it's still the same contract. The contract doesn't change because it's been.
That's the problem I have. You see, I can see the point that you say that the estoppel creates a situation in which the contract is read differently as between these parties because there is a binding principle that means that the TPC goes out. Understand that if the estoppel operates. Surely that must mean that that bargain minus the TPC is that which you've affirmed.
No, for this reason. The consequence of the affirmation is to leave the contract such as it is in place.
Yes. You say the contract is something different from what everybody else has signed up.
Well, there are, because each underwriter enters into a separate contract. And I mean, I don't say that flippantly. I just say it because that's the case. But if you look at the policy as a document composed of numerous contracts, so it's the same terms.
I'm well aware of how the reinsurance.
My lady, I'm not trying to inflame you in any way. I'm just trying to set up my submissions in answer to your question. But the reason why it's not relevant is because the right of avoidance is lost by virtue of an affirmation, or contractually by virtue of the TPC, one way or another. Because the TPC prevents you from avoiding in the event of a non-fraudulent misrepresentation.
The NAC, I think you mean.
I beg your pardon, the NAC, you're quite right. And so all that the loss of avoidance does is say you cannot rescind or set aside the contract. It doesn't say anything about whether or not any other principle of justice, such as an estoppel, allows the parties to treat any particular term as existing or non-existing, or as being interpreted in a particular way or not. That's a matter of estoppel. It's nothing to do with avoidance or affirmation. And as I said, if there had been no avoidance at all or affirmation, and there was always a contract which was sound, the estoppel point could always be still advanced, even though the parties signed up to a contract which included the TPC. And in any event, my lady, as I said before, the affirmation here is not one which is relevant because there was no right to avoid in the first place because of the NAC.
Can I read you what I've written down?
Of course.
I think it might. So, the right of avoidance is lost either by the NAC, or acts of affirmation. But all the loss of avoidance does is say you cannot rescind. It says nothing about whether the parties treated the contract by convention as not containing one or more of its terms.
Correct.
Right.
Or it could go beyond that, or a convention could exist as to how the terms should or shouldn't be interpreted. But it doesn't stop.
Or how they shouldn't be interpreted.
Yeah.
Yeah.
But,
Okay.
so my submission is that the affirmation is irrelevant to this question of estoppel. I mean, I can see why it might be superficially attractive to suggest that because you're affirming the contract, you should be taking the entire contract with each of its individual terms as being in full force and effect. And in a sense, that's right. But
Could you not look at it the other way, Mr.
Yes.
Eggers, and say what you're saying is that the judge dealt with it that way round, but if he dealt with it your way round and said, I'm going to deal with paragraph 29 of the pleading first, and then come to what happened after the pleading had been pleaded,
Yes.
we wouldn't be having this argument. And so the reality is affirmation is a little bit of a red herring.
Great.
Here. I don't think the point I put to you at the beginning is a red herring still, but I see your answer to it now, and that's what you're now going to make good.
I am during the course of my submission.
Yes, good.
I can't say it's going to be my next point because I do want to make a number of points.
No, okay, well, you can make points in any order. You
No,
want.
I have sort of delved into sort of subsequent submissions which I'm going to make. But there's one additional point I'd like to make as well, because we have been discussing the duty of good faith and affirmation and avoidance and the like. And there was one incidental point which was raised during the course of my learned friend's submissions yesterday, that the underwriter should be presumed to know the purposes of disclosure, the terms of the policy which that underwriter is signing up to. That's section 18.3, subsection B
Yes.
of the Marine Insurance Act. And the answer to that, of course, is that's correct, but it's not correct when one deals with a misrepresentation. The exception set out in section 18.3b applies only to the duty of disclosure. Misrepresentation is dealt with in section 20. It's an entirely different code. Moreover, section 18.3 begins with the words, in the absence of inquiry. And so the exception doesn't even begin to play, because here both underwriters asked, and a representation was made in response.
Yes.
Now, before I go on, I know also reference was made to another point which was also argued about rectification. And I think the rectification argument in this case, as far as I can tell, was an argument based on a common mistake, based on a conversation between the leading underwriter and the broker, which the judge didn't accept. And my
Judge didn't what?
did not accept.
Didn't accept.
But what was concerned was that the rectification argument boiled down as to the meaning or effect of the TPC, not as to whether the TPC was or was not in the policy. It's a different point. And my learned friend referred to the fact that it's a high bar. This morning, I think she referred to the editors of McGillivray, who said that there's a high bar for the purpose of establishing a rectification. I think my understanding of the evidence is you always have to have a cogent case for rectification, no matter what the contract. It's always a difficult hurdle. But my chief point is that rectification is not the decision made by the judge based on rectification, based on common mistake.
It was about the meaning of the TPC, not about the TPC.
And so it's not
being
inconsistent
in
with
the
any
contract.
finding about
It's not directly applicable.
No.
No, I get that.
With that, so what we say in
So
these...
it all comes down on the way you see it and the way your submissions are going.
Yeah.
It all comes down to whether or not you're right to say that the judge's previous findings about misrepresentation have any impact, are inconsistent with the later findings about Ark and Advent.
And I say no. There's no...
You say no for reasons you'll elaborate, but that you say we shouldn't get obsessing about either affirmation or rectification.
No. It's not inconsistent.
I mean, although there is an analogy, isn't there? I mean, this just for my own
Of course.
sort of view of the law, there does seem to be a bit of an analogy between rectification for common mistake and for unilateral mistake, with estoppel by convention, by a conventional understanding shared between the parties, and the concept of estoppel by convention by acquiescence.
Yes.
There does seem, anyway, a superficial attraction.
Yeah, I see that. Although it is interesting when it comes to unilateral mistake, because the law, of course, is in an uncertain state as a result of great peace.
Well, there's so few cases on unilateral mistake.
And also, people forget, I'm sure my lord has not, but people forget that rectification also applies not just in cases of common mistake, but unilateral mistake. My lady obviously is aware of it as
People
well.
don't forget that who tried Daventry.
It's true.
But the general test is either, when you have a unilateral mistake, the general test is either because one party is aware of the mistake, of the mistaken party's mistake, or has encouraged it. So it's not just a element of dishonesty conduct. It goes beyond that. And here we're in the encouragement camp rather than the knowing camp.
Well, are we really in an encouragement camp?
Well, I say we are.
You say we are, but you say we are simply by words. Words, you go along to the underwriter and you say, this is as expiry, and then there's a long discussion about how it's not as expiry. And your case is all based upon that initial introduction of the box. This is as expiry, whatever it was, and it's hardly an encouragement. I mean,
Well,
even if it's a misrepresentation.
Well, what is important, if I may say, my lord, is that in insurance context, the words as expiry, particularly in the process of broking the slip, which is about to be signed, are meaningful words.
Yeah.
And the judge has found that the underwriters were induced by those words. And there's no challenge to the finding of inducement.
No, I agree that's your strongest point. And that's why you took us through every paragraph of that finding.
I didn't mean to. I'm sorry, it was too laborious.
It's good to look at it again.
Yes. And so, it's important to bear in mind, firstly, that the judge found there was a representation. It was understood in a particular way, and it was relied upon. And essentially, there's no challenge to those findings. So we say in those circumstances, we say plainly in estoppel by convention, which I understand requires a little bit of unpacking, which I'll proceed to do, but also in estoppel by representation, which is our respondent's measures. And in a sense, I have to prove more for an estoppel by convention than I do for estoppel by representation, I say, because an estoppel by representation is quite a simple list of requirements, whereas estoppel by assumption, the court will have to engage with this issue about knowledge and cross purposes, which I'm about to enter into. Those issues do not arise in relation to estoppel by representation. So the three grounds of appeal, which Edge advanced in support of this appeal, are firstly, there was no shared assumption, so the parties were at cross purposes. And that's been supplemented by this new point about knowledge. There's a lack of knowledge. And I'm not, I should point out that the order of events in terms of the skeletons is Edge served their skeleton in support of their appeal. We served a respondent's skeleton afterwards. Then we served a supplementary skeleton referring to Tinkler and Jones and Leiden, which was followed by Edge's supplementary skeleton, which introduced this knowledge element for the first time. So what you don't, the court does not have a written submission based on the knowledge issue from me. And so I don't want to be, and I'm not complaining about that. I'm just saying that I'll be developing my submissions in response to that orally. But you don't have a skeleton which addresses the knowledge issue.
Well, you've already told us you don't agree with the two first instance cases relied upon precisely.
Yeah, well, I don't agree or distinguish them either way. So if I can deal with the, that's the first ground of appeal. The second ground of appeal is the NAC clause, which I'll then address. The third ground of appeal is the unconscionability or the injustice point. And then finally, I will deal with the respondent's notice, which is estoppel by representation. And I should make it clear, we may have referred to it as the equitable estoppel or promissory estoppel. That's not what I'm putting forward. It's estoppel by representation.
Estoppel by representation. Yeah. I am relieved by that.
Yes. Now, I think the first thing I would like to do, if I may, is take you to, and I'm taking you to this judgment for good reason, overnight or this morning, you should have received a copy of Republic of India.
Yep.
So
I thought we had it already.
no, it's
didn't.
quoted frequently, but
So we're going to the Republic of India.
we are. So all I really want to do, I don't need to explain the facts, but except for one thing, I think I might want to add, is one of the arguments addressed before the House of Lords. You can see it, 901. I hope your copy has letters down the side. D.
Sorry, did you say 891?
901. 90. And one of the arguments being put forward by Mr. Rokerson was there was no distinction made by the judge between estoppel by convention and estoppel by acquiescence. That's the last sentence of the paragraph by letter D.
Yeah.
Okay, so then we can move on, I think, to page 913. And under the heading estoppel, the law, Lord Steyn.
So how many judgments were there?
I think there were just. I think there's one. Yes, one, and all the other law lords agreed.
How refreshing.
I'm sorry, madam.
How refreshing.
It may not happen as much as we'd like.
Well, it was Lord Steyn.
It was.
Good.
And at 913, under the heading estoppel of the law, Lord Steyn begins, the plaintiffs rely in the alternative on estoppel by convention and estoppel by acquiescence to defeat the applicability of the bar created by section 34. A general review of the requirement of these estoppel is not necessary. And then he says it's settled that an estoppel by convention may arise where parties to a transaction act on an assumed state of facts or law, the assumption being either shared by them both or made by one and acquiesced in by the other. So just pausing there, Lord Steyn is making a distinction between two subspecies of estoppel by convention. One is a shared assumption, where they both entertain the same assumption, which is shared. So the very word shared means there's some crossing of the line, as opposed to common assumption. And the second is where one party makes an assumption, but the other acquiesces in it.
I mean, shared doesn't necessarily mean crosses the line,
But
it does mean that it's shared subjectively.
yes, but it's not enough that they coincidentally
No.
have the same assumption as you.
No.
Something
I mean,
more.
if, for example, it came from a third-party source,
Correct.
say, for example, broker sends to insurer and insured, I mean, you know, that would
Yes.
be all right.
Exactly, and that could be a crossing the line anyway.
Yes.
Yeah. But the other subspecies is where one party makes an assumption, but the other party acquiesces in it. And then Lord Steyn discusses the effect of that estoppel by convention. And
Is that a discussion of both subspecies or only one of them?
I think it must be for both.
Yes, that's how I read it. So when he says it's not enough that each of the two parties acts on an assumption not communicated to the other, that applies both to subspecies 1 and subspecies 2. An assumption made based on an assumption made by one and acquiesced in by the other.
Yes, although in the case of the second subspecies, only one party acts on the assumption, not the other.
Yes, it's really, I'm focusing on the words not communicated to the other.
Oh, no, yes, I think the communication, the crossing of the line is an essential element of both.
Yeah.
the and then Lord Steyn says, so far there was no disagreement about the law. And then at letter H, he then says, that brings me to estoppel by acquiescence. The parties were agreed that the test for the existence of this kind of estoppel is to be found in the dissenting speech of Lord Wilberforce and Moorgate against Twitchings. That the question is whether, having regard to the situation in which the relevant transaction occurred, as known to both parties, a reasonable man in the position of the acquirer of the property would expect the owner, acting honestly and responsibly, if he claimed any title on the property, to take steps to make that claim known. And then Lord Steyn says, making due allowance for the proprietary context in which Lord Wilberforce spoke. The observation is helpful as indicating the general principle underlying estoppel by acquiescence. And now, just pausing there before I go on, what's important is, what Lord Steyn is making clear is, firstly, that estoppel by acquiescence is a different doctrine or principle than estoppel by convention, because he's treated one first and then the other second. And Moorgate and Twitchings is not an estoppel by convention case, it's an estoppel by acquiescence case. And I said earlier, the estoppel by acquiescence often arises in a proprietary or a promissory estoppel context, and I think its history was in proprietary estoppel, and as noted by the Lord Steyn here. And then Lord Steyn goes on. The question
what were the facts of Moorgate Mercantile? I'm sure we should remember.
Oh, it's in the judgment's in the bundle. I can't remember offhand. I'm sure someone else can.
Right, but the acquirer and the owner, in what circumstances was he going to honestly and responsibly, if claiming title, have to take steps to make that claim known?
I think I'll have to remind myself of the judgment during the break.
All right. Well, you do it every break and let me know.
That's right. I remember now. It's a hire purchase agreement.
Yes.
Yeah, that's right. It was.
So why did the acquirer is this the acquirer, a third party acquirer?
It was a car dealer, I think. There was a finance company, a car dealer, and the car dealer bought the car from someone else. And the question was whether the car dealer could establish an estoppel by convention against the finance company. Now, that's the issue.
Wasn't it about whether there was a hire purchase agreement?
There was, yes.
I mean, I think I do need to be clear as to who acquirer and owner is in this context.
And I'll come back to
Let's come back to it, yeah.
Because I can't answer my Lord.
No, it's important though, maybe.
But if I could just revert back to Lord Steyn.
Yeah.
At letter C on this page, he says the question was debated whether estoppel by convention and estoppel by acquiescence are but aspects of one overarching principle. I do not underestimate the importance in the continuing development of the law of search for simplicity. I also accept that at a high level of abstraction, such as an overarching principle could be formulated. But Mr. Rokerson, for the defendants, persuaded me that to restate the law in terms of an overarching principle might tend to blur the necessarily separate requirements and distinct terrain of application of the two kinds of estoppel. And of course, then he pays tribute to Mr. Rokerson in the final sentence. And as you can see from this page, Lord Steyn then addresses estoppel by convention on the facts, and separately estoppel by acquiescence on the next page, on the facts. So what I get from this judgment, my lords and my lady, is this, that there are two subspecies of estoppel by convention. The first is one where there's a shared assumption. And the second is where one party makes an assumption and the other acquiesces in it. And the second proposition I get is estoppel by convention and estoppel by acquiescence are two separate doctrines with their own requirements.
And that was Mr. Rokerson's last non-arbitral appearance as counsel in the House of Lords.
I saw that. And that's 23 years ago, some time.
I know, I remember. Yeah, amazing. Anyway, so that's clear, those submissions,
Yes.
and obviously correct.
Yes.
from that case.
Now, the reason I've taken time with this is for two reasons, which I now develop. The first reason is, I think the principle, well, I say principle, the first ground of appeal which my learned friends had relied on was that the parties were at cross purposes as to the assumption. But I say that's irrelevant as far as the second subspecies of estoppel by convention is concerned.
Well, can I just ask a question about
Yes.
that? What I think she's really saying is that the assumption of the representor was different from the understanding of the representee.
Yes.
And the representor did not know that the representee had that different understanding.
Yes. Well, that's and I don't object to it. That's aligning the two arguments I think my learned friend's putting forward. I'm happy to deal with it on that basis.
It may be, but it is actually the what she says.
Yes. Well, let me put it another way, if I may. It doesn't matter that for the purposes of an estoppel by convention based on acquiescence, that the representor, in this case Edge, does not have the same assumption as the representee. So the fact that there are cross purposes is not relevant.
Why not?
Because, as Lord Steyn said, only the first subset, or third subspecies of estoppel by convention requires the sharing of an assumption. The second subset doesn't require a sharing of an assumption. It requires one person making an assumption, the other one acquiescing in it.
Yeah, well, that comes back to my lady's repeated questions to you earlier about what acquiescent meant.
Yeah, so, and I will come back to that. I'll make my submissions. I've already given you.
I mean, I'm sure you wouldn't want to have a look at such a book, but Spry might be a book to look at in this context.
Yes, it's a very large book, but I'll have a look.
It was never large in the old days. It
mean,
has grown, I agree.
I find it very hard to navigate sometimes, but it's not a criticism of the book itself.
I didn't write it this time.
But I will look. The second aspect of the question of knowledge, I'll address that separately. But just as far as the first aspect is whether or not both parties must entertain the same assumption, there is no such requirement, I submit, for the purposes of an estoppel by convention based on acquiescence. And one has to be very careful when considering the authorities in this respect. So Tinkler is a prime example. Even though Lord Burroughs refers to and cites Lord Steyn's judgment in Republic of India, which as per the quotation I've read out, the court was really not concerned with acquiescence in that case. It was concerned with the common assumption. So occasionally you will see the court setting out what principle or what the requirements are for an estoppel by convention.
So Tinkler is a non-acquiescence, non-contractual case,
Correct.
which you say has got not much to do with this.
No, I was the one who referred to Tinkler first. In my
He
supplement.
did say, he didn't hear paragraph 78, all this applies to contractual cases.
He'd certainly aligned, and he does that based on what he cites authority in support of that proposal. But I'll come back to that.
Okay. So we don't think Tinkler's the last word.
Yeah, well, Tinkler is certainly the latest word from the Supreme Court, and that's not to be ignored. And there's nothing in Tinkler which I think causes any difficulties at all. But one has to be very careful when seeing whether Tinkler or the Court of Appeal's judgment in another decision called Triodos Bank, which is Lord Justice Longmore's decision, when the courts may set out what the requirements are for a estoppel by convention, very often they're concerned with a common or shared assumption as opposed to, if you like, an acquiescence. And indeed, my lord, my lords and my lady, if you look at the textbooks, often the acquiescence subspecies of estoppel by convention is given very little discussion. it's identified, but it doesn't get the same amount of treatment.
Right. Now, I wonder if that might be a convenient moment.
Very convenient.
Mr. Eggers, it is possible I may be a little late returning. I'll try not to be. But we have a swearing in over lunchtime.
I understand.
Quite a heavy lunch.
So is it at 2 o'clock?
We'll sit at 2, and
But you may be
hopefully I'll be here, but I may be in court 4, and I'm not as quick as I'd like to be in getting from one place to another and changing clothes.
I understand.
I'll be back as quick as I can.